with panel 3. And our first witness is Edna Axelrod, who's known Judge Alito for nearly 20 years, having worked with him when he was United States Attorney. She is a sole practitioner in South Orange, New Jersey. She served in the U.S. Attorney's Office from 1980 to 83 and 85 to 94 during Judge Alito's tenure as U.S. Attorney. She had important positions as Chief of the Appeals Division. She is a graduate of Duke's Law School and a master's degree in law from Temple, and we welcome you here, Ms. Axelrod. We're going to have to be mindful of the time because we have 4 panels and about 23 witnesses.
You'll finish tonight?
Well, I would like to, but it's subject to negotiations with you, Senator Leahy.
Mr. Chairman, can I just ask unanimous consent a number of letters I have and usual things to put in the record?
Sure. Without objection, they will be made a part of the record. Thank you, Ms. Axelrod, for being here, and we're starting the clock at 5 minutes.
Thank you. Thank you, Mr. Chairman and members of the committee. I appreciate the opportunity to appear here today to testify in support of the nomination of Samuel Alito. I am a former Chief of the Appeals Division at the United States Attorney's Office for the District of New Jersey, and for the past 11 years I have practiced as a federal criminal defense attorney in northern New Jersey. At this point in these proceedings, I am sure there is little need to provide further comment concerning Judge Alito's legal acumen and outstanding accomplishments. However, I hope that the committee may find it useful to hear the insights and observations of someone who worked closely with Judge Alito during the period of time that he served as United States Attorney for the District of New Jersey. I first met Judge Alito when I joined the United States Attorney's Office in 1980. At that time, he was laboring in the Appeals Division, and I was in the Frauds Division. As a rookie, I quickly learned that if I ran into a particularly thorny legal or procedural problem, the most knowledgeable and approachable person to consult was Sam Alito. Although he soon left for the Solicitor General's office, he returned in 1987 as United States Attorney. Shortly after his arrival, he began selecting the supervisory staff who would assist him during his tenure, and after reviewing my work in the Appeals Division, he asked me to serve as Chief of Appeals. This was particularly meaningful to me for 2 reasons. First, Judge Alito's estimable reputation as an appellate and Supreme Court advocate had preceded him, and the importance that he placed on the appellate process was well known. Second, in 1987, it was still unusual for women to be elevated to positions of authority in either government or private offices, and I was gratified to see that Judge Alito's appointments were based on merit, not gender. As a member of the supervisory staff, I met frequently with Judge Alito, sometimes alone, but usually with other division chiefs, to discuss ongoing, significant criminal prosecutions, appeals, and investigative initiatives. During these meetings, he openly invited the thoughts and input of everyone, asking subtle questions to guide the discussion to areas where he had concerns. Although it was clear that in the end he would make up his own mind, it was equally clear that there was no danger in advocating a position that he might ultimately reject. His goal was to get as much information as possible so his decisions could be firmly grounded in a comprehensive understanding of the law and the facts. Consistent with this approach, his stewardship of the office was grounded in quiet confidence. His decisions and actions were measured and thoughtful, never impulsive or purely reactive. Although it is possible for U.S. attorneys to use their offices as showcases for themselves and their further aspirations, that is, to enjoy and employ the limelight, this was never Judge Alito's way. It was always the work, not the image, that came first. It is a well-known motto of federal prosecutors, one most often heard on those occasions when they suffer a defeat, that the United States wins when justice is done. Under the leadership of Samuel Alito, and I should say Judge Alito, that was more than a catchphrase. It was office policy. Judge Alito expected the assistants in his office to work hard to achieve and preserve convictions where the evidence supported guilt, but he also demanded that they remain ever mindful of the very great power that they wielded as federal prosecutors and the need to use that power with appropriate discretion. Based on my experience in that office, I am confident that Judge Alito would approach the power of being on the Supreme Court with an equal, if not heightened, sense of responsibility and care. As I noted earlier, I am presently a criminal defense attorney, and I am also a lifelong Democrat. As such, I might be expected to have concerns about Judge Alito's nomination. However, in supporting his nomination, I am actually representative of a large number of former colleagues of Judge Alito, of all political stripes, who support his nomination because they know firsthand what kind of man he is. Those of us who know him know that he is not an ideologue and that he does not use his position to pursue personal agendas. We have seen his profound respect for the law and precedent, and his unfailing respect for all participants in the criminal justice system, prosecutor, defense counsel, and defendants alike. We know him to be a man of unquestionable ability and integrity, one who approaches each case in an open-minded way, seeking to apply the law fairly. The appointment of Sandra Day O'Connor to the Supreme Court in 1981 was an event of special importance to me. At the time, I thought that the most significant fact was that she was a woman, the first woman on the court, and of course that was truly groundbreaking. But in time, I have come to appreciate that more than her gender, it is her extraordinary mixture of character and intellect that has most profited our country. As a person of both great character and great intellect, Samuel Alito would be a worthy successor to Justice O'Connor, and I hope that he will be speedily confirmed. Thank you very much.
Thank you, Ms. Axelrod. Our next witness is Professor Michael Gerhardt, Distinguished Professor of Constitutional Law at North Carolina School of Law. Professor Gerhardt is the author of a number of books on constitutional law. He served as special consultant to the White House on the nomination of Justice Stephen Breyer. He received his bachelor's degree from Yale in 1978, master's from the London School of Economics, and law degree from the University of Chicago in 1982. Thank you for joining us, Professor Gerhardt, and the floor is yours for 5 minutes.
Thank you very much, Mr. Chairman, Senator Leahy, and other distinguished members of the committee. For almost 20 years, I've had the honor of teaching constitutional law. For almost as long, I've studied the process of Supreme Court selection in some detail, and have had the privilege and opportunity to write about it at some length. And I come to you today with the hope that whatever expertise I've developed in that process may be of some use to you. In this statement, I want to just make 3 brief observations as extensions of my written statement, which you already have. First, the Constitution allows every senator to make a decision about a Supreme Court nomination based on whatever factors he or she considers to be pertinent, including judicial philosophy. The Constitution, I believe, does not require absolute deference to a president when it comes to making Supreme Court nominations, nor, for that matter, does it require hostility. The Constitution allows you, I think, to do what you see fit. It allows you to engage in a robust dialogue about the qualifications for service on the Supreme Court. With that in mind, I just want to give you one brief example of what I'm talking about, what the Constitution allows, just as to illustrate, I think, the robustness of the process, that we shouldn't be ashamed of it, but in fact should be prepared to embrace. Much has been said that, about the fact that Judge Alito has had the most judicial experience of any nominee made to any nomination made to the Supreme Court in almost 70 years. But nobody mentions who that other nominee was. That other nominee that preceded him was Benjamin Cardozo. And Cardozo, as we probably all know, was not President Hoover's first choice, wasn't even President Hoover's second choice. In fact, he was the choice of the Senate. And then senators came to the president and said, in fact, members of this committee came to the president and said, in effect, that this is the person we want, here are the criteria we think are important. President Hoover was not obliged in any way, shape, or form to accept that, but he did. And I simply make that observation to underscore the fact that there is an opportunity for exchange between the presidency and the Senate with respect to a Supreme Court nomination and we should be prepared and as open as possible in talking about the qualifications for service. And again, if each of you believes to some extent judicial philosophy is appropriate, it's important to say so and to act accordingly. Secondly, you know better than I the important function of this committee as a gatekeeper. You're in the position, at least the initial position, of being able to sort of filter out the views and personnel you don't want to see reflected on the Supreme Court, or you're in the position of determining what views or personnel you do want to have on the Supreme Court. The Supreme Court is largely a function of choices made by the President and the Senate. The Senate and the President help to make the Supreme Court what it is. And I think that dual partnership is something we ought to keep in mind, because in making determinations and judgments about a Supreme Court nomination, the Senate has an extremely important role to play. And the more vigorously you perform that role, I think the more credit it does to you, and the more we can be assured that whatever choice gets made about the people that serve on the court, that we can have confidence that they can be there, that they can trust the judge, that they're worthy of the trust you've given them to exercise the awesome power of judicial review over the constitutionality of not just your actions, but the actions of other branches. Third, I must confess, and I regret this, an error in my written statement. I discussed in this written statement the importance of assessing whether or not Judge Alito was a bottom-up or top-down judge. A bottom-up judge is somebody who decides cases incrementally, one at a time, and has a great deal of respect for precedent. A top-down judge is somebody who tends to infer principles directly from the Constitution and then impose them from the top down. And in the course of trying to figure out whether Judge Alito was bottom-up or top-down, I made a mistake in not identifying Justice Harlan as one of the justices he most admires. I just want to sort of correct that error. The reverence for Justice Harlan is almost universal. He's certainly one of the justices I most admire. But the admiration for Justice Harlan does raise a question. And the question is this. How, if at all, does Judge Alito's reverence for Justice Harlan make him the same kind of judge or a different kind of judge than other justices who also have admired Justice Harlan, including Justice Kennedy and Justice Souter? Is he the same kind of judge as they are, or is he a different kind of judge? Reverence for Justice Harlan is obviously pertinent, it's important, but it may only tell us so much, and I think it's useful and very important for you not to shy away from asking the tough questions. You have asked the tough questions. I think it does you credit. I think that's what this process is all about, and I am privileged to be a part of it. Thank you.
Thank you very much, Professor Gerhardt. Our next witness is Commissioner Peter Kirstenau, a U.S. Commission on Civil Rights, partner with the law firm of Benish Friedlander. He's also on the board of directors of the Center for New Black Leadership and on the advisory board of the National Center for Public Policy Research. His bachelor's degrees from Cornell, a law degree from Cleveland State with honors. Commissioner Kirstenau has reviewed Judge Alito's civil rights record and will testify as to his conclusions in that area.
Thank you, Mr. Chairman, Senator Leahy, members of the committee. The U.S. Commission on Civil Rights was established pursuant to the 1957 Civil Rights Act, among other things, act as a national clearinghouse for matters pertaining to discrimination and denials of equal protection. And in furtherance of the clearinghouse responsibility, and with the help of my assistant, I've reviewed the civil rights cases in which Judge Alito has participated on the Third Circuit, as well as his record as an advocate before the Supreme Court in the context of prevailing civil rights jurisprudence. Our examination reveals that Judge Alito's approach to civil rights is consistent with the generally accepted textual interpretation of the relevant constitutional and statutory provisions, as well as governing precedent. His civil rights opinions evince appreciable degrees of judicial precision, modesty, restraint, and discipline, and in short, his civil rights record is exemplary, legally sound, intellectually honest, and with an appreciation and understanding of the historical bases undergirding our civil rights laws. Our examination also reveals that several aspects of Judge Alito's civil rights record have been mischaracterized, some of the criticisms misplaced. Just three brief examples. First, some have contended that Judge Alito has a regressive or anti-civil rights view of affirmative action, one that's to the right of Justice O'Connor. This contention is based on three affirmative action cases in which Judge Alito participated on brief, while he was with the Solicitor General's office in the Reagan administration. These three cases are Wygant versus Jackson Board of Education, sheet metal workers versus EEOC, and firefighters versus City of Cleveland, all of which involved expansive racial preferences as remedies for discrimination. Notwithstanding the fact that positions espoused as an advocate are poor proxies for interpretive doctrine, there's nothing in the record to suggest that Judge Alito would somehow restrict remedies currently available under United Steelworkers versus Weber or Johnson versus Transportation Agency any more so than Justice O'Connor would. Judge Alito essentially argued that rigid quotas are unlawful, and opposition to quotas and expansive racial preferences do not evince a hostility to affirmative action, let alone civil rights in general. Second, some critics have said that Judge Alito's decision or dissent in Bray versus Marriott is evidence of his supposed tendency to impose, quote, almost impossible evidentiary burdens on Title VII plaintiffs, end quote. But a review of Bray shows that Judge Alito's dissent actually steadfastly adheres to Third Circuit precedent and carefully applies the law to the facts, whereas the majority opinion seems to dilute the commonplace standard of proof in a Title VII case by reducing or converting the burden of production on the part of a defendant into a burden of proof. The third contention, unsupported by our examination, is that Judge Alito's civil rights record is out of the mainstream. Judge Alito participated in 121 Third Circuit panels that decided cases that may be termed, in the traditional sense, civil rights cases. Now, one would expect that if someone were out of the mainstream, that by definition, he would rarely agree with his colleagues on the Third Circuit, and moreover, you would expect that he'd almost never agree with his Democratic colleagues and would vote overwhelmingly with his Republican colleagues. But an examination of Judge Alito's extensive record on the Third Circuit shows that his co-panelists on civil rights cases actually agreed with his written opinions and votes 94% of the time, and that's whether or not those panelists were Republican or Democrat, and in fact produced unanimous decisions 90% of the time. Moreover, judges appointed by Democratic presidents actually agreed with Judge Alito's civil rights positions at a slightly higher rate than his Republican colleagues, by a margin of 96% to 92%. In fact, judges appointed by Democratic presidents Johnson, Carter, and Clinton agreed with Judge Alito's civil rights position at the same or slightly higher rate than judges appointed by President Reagan or either President Bush. Now, obviously, in order to thoroughly assess Judge Alito's civil rights cases, you have to look at the actual facts and applicable law in each case. But it cannot be credibly stated that Judge Alito is hostile to civil rights out of the mainstream or extreme without leveling the same charges against every other judge on the court, whether Republican or Democrat. I would respectfully submit that Judge Alito's 24-year record on matters pertaining to civil rights demonstrates a firm and unwavering commitment to equal protection under the law, and he has a comprehensive and precise understanding of our civil rights laws that will make him an outstanding addition to the Supreme Court. Thank you, Mr. Chairman.
Thank you very much, Commissioner Caruso. Our next witness is Professor Samuel Alito, Rice Professor of Constitutional Law at New York University School of Law, and author of several books focusing on voting rights and civil procedure. He had taught at the Texas Law School, bachelor's degree from Binghamton University in 1973, and law degree from Yale in 1983. Thank you for joining us, Professor, and we look forward to your testimony.
Thank you, Mr. Chairman, Senator Leahy, members of the committee. I want to direct my remarks to the question of the reapportionment cases and the significance of the court's role in overseeing the basic fairness and integrity of our political process. And I raise this issue because the reapportionment cases stand for something beyond simply the doctrine of one person, one vote. They also stand for the role that the court has to play in making sure that the political process doesn't turn in on itself and doesn't close out those who are not able to effectively marshal their votes, their power, their support under the rules that govern the political process. It's significant because no justice of the Supreme Court over the past 35 years has hesitated to assume the responsibilities so well articulated by the Supreme Court in the famous Caroline Products footnote. Justice Stone in 1938, on behalf of the Court, recognized a special need for exacting judicial review in the case of laws, and this were his words, that restrict those political processes which can ordinarily be expected to bring about repeal of undesirable legislation. The reapportionment cases of the 1960s, the cases that appear to have so deeply concerned Judge Alito as a young man, were the realization of the Caroline Products insight. In the 40 years that have passed since the reapportionment cases, the Supreme Court has bravely entered into the political thicket. Sometimes the Court's role is simply what appears to be routine, such as access to the ballot and the polling place. Sometimes it is the truly extraordinary, as with Bush v. Gore. The result of these interventions, although obviously not without controversy, is a political system that is more open and more participatory than at any time in our history. It is difficult to imagine in this day and age any serious objection to the rights identified in these cases. In Reynolds v. Sims, for example, Chief Justice Warren wrote that full and effective participation by all citizens in state government requires that each citizen have an equally effective voice in the election of members of his state legislature. But it is also well to recall the facts presented in these cases. The willful failure to reapportion had transformed American legislative districts into grossly unrepresentative institutions in which voters of the growing cities and suburbs found themselves unable to participate effectively in a political process controlled by rural minorities. In Alabama, the site of Reynolds v. Sims, one county had 41 times as many representatives per person as another. That pattern was repeated across the country. In California, to pick just one, Los Angeles County had one state senator, as did another county with 1/100th of its population. While the basic principle of one person, one vote may now be so deeply embedded in our culture as to seemingly defy any controversy, its implementation was another matter, and I think that's what's significant about these cases. Those whose votes were discounted to the point of irrelevance were repeatedly frustrated by entrenched political power. The intervention of the Supreme Court was indispensable. Indeed, it was the single most successful remedial effort by the Supreme Court in our history. It changed and made fundamentally more democratic the legislative process, and it made the legislative process one that was deserving of judicial deference. When I teach these cases today to students, however, and even when I was a law student in the early 1980s, the idea of one person, one vote appears so elemental, so in keeping with the most rudimentary sense of democracy and legitimacy, that students cannot even fathom that a society, a democratic society, could be organized on any other basis. I do not know how a young college student in 1970 might have reacted, particularly when presented with the formidable writings of Alexander Bickel. Bickel captured well the tension between a commitment to popular sovereignty and the overriding commands of the Constitution. And it is well to remember that although we turn our attention here to the court, it is obviously the Congress that is a significant and major institution expanding our democratic horizons, as with the Voting Rights Act of 1965. Nonetheless, I would suggest that the fact that the reapportionment cases should appear on a job application in the 1980s is at least a curiosity. Perhaps it was the recounting of an intellectual path, but perhaps an indication of a continuing view that courts have no business in checking the abuses of political power. If it is the latter, it should be deeply troubling to this committee and to the Senate. For the issue of the day is not the intellectual trajectory of a thoughtful college student, but the implications for the vital role the Supreme Court plays in our democratic life. Critical issues in the organization of our democracy remain unsettled and are going to appear as they do before the court. Our system of redistricting has run amok, the competitive lifeblood drained by self-perpetuating insiders. This may prove to be the same sort of structural obstacle to democratic reform as had to be dislodged by reapportionment decisions of 40 years ago. The answer may not be simple, but the role of the court is absolutely critical. So too with campaign finance, so too with even the mechanics of our electoral system. In all of these areas, there's reason to doubt that incumbent officials are able to fix the political process that elected them. As Justice Scalia has wisely cautioned, the first instinct of political power is the retention of power. While not without controversy or difficulty, our collective experience over the past 40 years confirms that the nation is much the better for the robust attention of the Court to the health of our democracy. I would suggest to this committee and to the Senate that before confirming any nominee to the Supreme Court, the Senate of the United States should be able to conclude with confidence that, regardless how a nominee may vote on any given case, he or she will assume the full responsibility of protecting the integrity of our democratic processes. Thank you, Mr. Chairman.
Thank you, Professor. Our next witness is Mr. Carter Phillips, one of the premier appellate lawyers in the country. Has handled some 47 cases before the Supreme Court of the United States, some of those as assistant to former Solicitor General Rex Lee. He's a graduate of Northwestern School of Law, a clerk for Chief Justice Warren Burger, and rated as one of the 100 best lawyers in America by the National Law Journal. At your hourly rate, Mr. Phillips, thank you for joining us. And how much does 5 minutes cost?
Well, I won't answer that question, but I will tell you that the law firm has taken a hit today. Thank you, Mr. Chairman and members of the committee. It's oftentimes it strikes me that baseball metaphors tend to be used at these hearings, but it at least impresses me that perhaps a tennis metaphor is more appropriate at this point, based on the testimony of Judge Alito in the last 2.5 days and the extraordinarily eloquent testimony of the Third Circuit judges in the last hour or so. It would strike me that we ought to be at the point of game, set, and match, because it seems to me that there can be no serious question about either the qualifications on ability or ethics or any other standard that this committee would want to use in reviewing the qualifications of Judge Alito to become a Supreme Court Justice. You have my written testimony. I'm not inclined to repeat it at this point. And one thing I have learned as an appellate advocate is if you think you're ahead on points, you do well to sit down and shut up. So all I'm going to do is simply recount for you my own experiences with Judge Alito when we were in the Solicitor General's office. Not because I think they add all of that much, but I do think they debunk the notion that somehow Judge Alito has long been an ideologue of any sort. The judge and I met when we both interviewed with Judge McCree, who was President Carter's Solicitor General. We were interviewing for a job as an assistant to the Solicitor General. We had applied for that position prior to the election. Neither of us knew which direction that election was going to come out. We were seeking that position not because we had any kind of an agenda to fill, but solely because each of us hoped to get a very prestigious position. Now, as it happened in that first meeting, Judge Alito and I ended up being seated together by ourselves when all of the other members of the Solicitor General's office went off to another table. And we had what I think is fairly described as at least a little bit of an uncomfortable conversation because we assumed we were competing for exactly the same job and had a very interesting exchange of views about our backgrounds and our experiences, he being an existing assistant U.S. attorney with an extraordinary amount of experience as an appellate lawyer, I being a former law clerk and at that time an assistant professor of law. But we built a great friendship based on that conversation and the fact that we both ended up in the Solicitor General's office. But what struck me is that whether or not the Solicitor General had been Wade McCree or whether, as it turned out, the Solicitor General was Rex Lee, our service to the United States would have been precisely the same. And the only other thing I would say in that regard is that during the 3+ years that I served with Judge Alito in that office, I had an opportunity to talk with him almost every day. And in that capacity, I learned an enormous amount from him about both his compassion and his intellect and his open-mindedness and his enthusiasm to assist all of the lawyers in that office. He was a great lawyer. He was a tremendous oral advocate. He went on, obviously, to a very distinguished career. While I have my own opinions about what he's accomplished on the Third Circuit, it seems to me I cannot add to the eloquence of what's already been said by the judges of that court. And I would simply urge this committee to confirm his to justice.
Thank you very much, Mr. Phillips. Professor Gordon Liu is an expert in constitutional law, civil rights, and the Supreme Court at the University of California, Boalt Hall. He is a graduate of Stanford with its bachelor's degree, a master's from Oxford, and a law degree from Yale Law School in 1998. He served as a law clerk for Supreme Court Justice Ruth Bader Ginsburg during the October 2000 term. Thank you for coming in today, Professor Liu, and we look forward to your testimony.
Thank you, Mr. Chairman. I'm very honored to be here today. I agree with all of my fellow panelists that Samuel Alito has a very talented legal mind. I've read over 50 of his opinions. They're very sharp, analytical, intellectually honest. But if intellect alone were enough, then these hearings would be unnecessary. We care about the judicial philosophy of the nominee. And so to prepare for these hearings, I studied Judge Alito's opinions on individual rights versus government power. His record is enormous, and Mr. Chairman, as you've said, cherry-picking cases is not very informative. Neither is it very informative to look at the entire run of all cases. What is informative, I think, is a look at the closest, most contested cases, cases where judges on a panel disagreed. These are the cases most like the ones at the Supreme Court. The law is less clear, and judges have to show their stripes. I don't think Judge Alito is an ideologue, but I think it's important to see what the record says. So I looked at several areas where government wields great power: immigration, the Fourth Amendment, criminal prosecution. In these areas, Judge Alito sat on 52 panels that divided between the individual and the government. He voted for the individual only 4 times, 3 times joining an en-banc majority, 1 time writing in dissent. In the other 48 cases, he sided with the government. This includes all 13 cases on the Fourth Amendment, all 8 cases involving erroneous jury instructions, all 4 cases involving the death penalty. On 13 occasions, his vote for the government was a dissent from an opinion written or joined by a Republican colleague. Most of the counterexamples cited in these hearings are not terribly illuminating. The constitutional violations were clear, the holdings were unanimous. In the contested cases, Judge Alito agreed with the government over 90% of the time, far more often than other appellate judges in similar cases, even those appointed by Republican presidents. Now, these figures are not dispositive. Every case is different, and I'm sure Judge Alito got it right many times. But let me give 3 examples that show his instinct, I think, to defer to government power. The first is a memo he wrote in 1984 as assistant to the Solicitor General, analyzing a case where police saw a burglary suspect running across a backyard. The suspect reached a fence, and an officer called out, "Police, halt." When the suspect tried to climb the fence, the officer shot him in the back of the head, killing him. The suspect, Edward Garner, was an 8th grader with a stolen purse and $10 on his body. He was not armed, and the officer did not think he was. The sole reason for his killing was to prevent his escape. Judge Alito's memo, speaking for no one but himself, said, "I think the shooting can be justified as reasonable within the meaning of the Fourth Amendment." In a remarkable passage, he argued that using deadly force to stop a fleeing suspect rests on, and I quote, "the general principle that the state is justified in using whatever force is necessary to enforce its laws." In 1985, the Supreme Court rejected this view. Second, in a 2004 case, the FBI installed a secret video camera in a suspect's hotel room. This was done without a warrant, on the ground that the FBI turned on the camera only when the target allowed an undercover informant into the room. Judge Alito accepted this logic, even though the camera remained in the room day and night. The dissent called the surveillance Orwellian, limited only by the government's self-imposed restraint. Judge Alito seemed not to grasp that the concept of a warrant puts a judge between the citizen and the police precisely because our privacy is too precious to entrust to law enforcement alone. The NSA program of warrantless eavesdropping is also being defended by assurances of executive self-restraint. Finally, in 1997, there was a capital case where 2 Reagan appointees, both former prosecutors, found a misleading jury instruction unconstitutional. Judge Alito said the instruction was ambiguous and inadvisable, but adequate to convict the defendant of first-degree murder. He also said the court should not have heard the claim at all because defense lawyers did not argue it in prior appeals. But the state never raised this argument to the inmate's claim. Judge Alito raised it himself. The court chided him for nearly crossing the line between a judge and an advocate. Civil liberties are sometimes seen as obstacles to law enforcement. But as Justice Frankfurter once said, the safeguards of liberty are often forged in cases involving not very nice people. Mr. Chairman, liberty is not safe in an America where police can shoot and kill an unarmed boy to stop him from escaping with a stolen purse, where judges occasionally aid prosecutions by raising arguments that the state itself did not raise, and where the FBI can install a camera where you sleep on the promise that they won't turn it on unless they have to. Mr. Chairman, this isn't the America we know, and it isn't the America we aspire to be. Thank you, Mr. Chairman.
Thank you, Professor Liu. Mr. Phillips, how would you evaluate the comments Professor Liu has made?
Well, with respect to the memorandum to the Solicitor General, I think the notion that that's an individual opinion is not a very apt description of at least what I viewed my role when I was an assistant to the Solicitor General. What we did in that context, and in this particular case, what he was doing was proposing that an amicus brief be filed on behalf of the United States in support of the state of Tennessee's position. In that process, you may, I mean, it may be that sentence, and I don't have the context of it to understand it completely, but at that stage, all he's doing is proposing that a brief be filed. It'd be interesting to see what the ultimate brief said and whether or not it staked out a position quite as aggressive. But you know, because that's part of the deliberative process that goes on. It's the same deliberative process that goes on with respect to the courts. You know, I mean, I don't disagree that it makes sense to look at the most contentious cases as a legitimate way to examine that. But again, I don't think you can take, and I do think this is the classic instance of cherry picking, I don't think you can take out one or two specific examples and say this somehow reflects anything about the body of work of a judge who's been on the bench for 15 years, and in the face of the testimony we just heard from colleagues of his who spent literally more than decades with him, and whose view is that he comes to each case with an open mind and thoroughly analyzes each one and performs this in a bottom-up, not a top-down process.
Mr. Axelrod, you know Judge Alito extensively. How would you respond to Professor Liu's testimony?
Well, I had the same reaction concerning the first case that was mentioned when he was in a role as an advocate and was trying to come up with the different perspectives that you would bring to a case as an advocate for the government, where your job is to figure out whether or not you're going to be supporting the result below. He was doing his job, and he was doing it appropriately. And the other cases, I think you have to look at the cases more closely than you can in basically a soundbite during a few-minute presentation. You have to look at the arguments that were made on both sides. You have to look at what the standard of review was. You need to see the facts. And I'm sure that the professor analyzed these cases ably, but I would not be persuaded simply by a short summary of them that the reasoning was unfounded, even if I disagreed with it, which I very well might have, without seeing more.
Commissioner Kurris, now, what is your evaluation of Judge Alito's record as it applies to civil rights issues with African Americans?
Well, it's, as I indicated before, it is exemplary. We took a look at several hundred cases, 121 specifically, and we drew a very broad net to encompass the broadest definition of civil rights possible, but also we drew a more narrow net for the more traditional civil rights cases, the Title VII cases where it's more likely that you're going to find an African-American plaintiff. And what we saw there is, and I refer to Bray versus Marriott, I think it's emblematic of the kind of approach Judge Alito has. He's very precise. Earlier on, I heard testimony with respect to is he in favor of the little guy or the big guy, and I think I would hearken back to Judge Alito's opening where he says that no one's either above the law or below the law. I don't think that he's outcome-driven. He's looking at upholding the law, whether or not that redounds to the benefit of the big guy or the little guy. And I think that's the classic example of someone who hews closely to the most profound protections of civil rights.
Professor Askaroff, Is there any doubt in your mind that Judge Alito will uphold the one-man, one-vote rule?
I don't think there's any doubt that he would uphold one person, one vote as an abstract matter. I think that the broader question that's raised by his earlier comments, and I heard nothing in these hearings that really address this, is a deeper one about the role of the court in checking the abuses of incumbent power. And so while I don't in any way question that he has, as much as all the rest of us have internalized the one person, one vote principle, my reservations would be on the willingness to use judicial power to check malfunctions in the political process.
Professor Gerhardt, you say that the Senate ought to be an active participant in the selection of Supreme Court justices. To what extent do you think that with a heavy campaign on the judicial issue, the President has latitude to pick judges as he wants on the political spectrum, and how could the Senate really effectuate your idea?
I think the idea I'm describing is the system that we've got. I don't mean to suggest a different kind of system, Senator. The President may do exactly as you suggest, pick somebody based on whatever criteria he likes. I'm just suggesting that I think it's perfectly consistent with the structure and history of our Constitution for senators then to provide an independent judgment of his criteria and to assess them on whatever other criteria they think are appropriate.
Red light went on during your answer, Senator Leahy.
I think he was referring to himself. Professor, good to see you again. If I just want to follow up on Professor Iskarov. And it's nice to meet your son Lucas here earlier. Now that way his name is in the transcript.
Thank you, Senator.
You know, we've talked about the 85 job application of then Sam Alito for a job in Ed Meese's Justice Department. He stated he developed an interest in constitutional law motivated in large part by disagreement with the Warren Court decisions, particularly in the areas of reapportionment. Now, in the questions he was asked here, he retreated from that unqualified disagreement and said it was based on certain details of later Warren Court decisions, like the 1969 case, Kirkpatrick versus Chrysler.
Yes.
That's incredible. He was telling Mr. Meese in 1985 that in 1969, as a young college student, he was so incensed by the Kirkpatrick case it motivated him to study constitutional law.
I think the Kirkpatrick case may have had some impact in the Alito household because of the particular role that his father played. But his statement refers to an intellectual excitement based on the writings of Professor Bickel of Yale. Professor Bickel was not concerned with the implementation of one person, one vote. Professor Bickel was concerned, as was Justice Harlan at the time, that the court should have no business in this area whatsoever, that whatever the political process did, whatever the malfunctions of politics might be, the courts simply were not to be engaged in that process. That's the idea that was animating Professor Bickel, and one has to assume was animating the young Sam Alito.
And of course, Justice Harlan was one of his heroes. Had we followed that idea, Harlan's dissent and others, we wouldn't have had reapportionment around this country, would we?
There were
unless reapportionment done politically by those who had reapportioned themselves out of office.
The history of the United States was that for the 20th century, until we got these cases in the 1960s, incumbent officials simply did not reapportion. They had a constitutional duty, including this body. In the 1920s, the Congress, the Senate of the United States decided not to reapportion. The Congress simply said, why should we reapportion ourselves out of business? We'll just refuse, even though we had a constitutional obligation. The lesson was that when power decides to close in on itself and pull the ladders up behind it, the courts have to be there. Professor Bickel was deeply disturbed by this, and when I read in 1985 that somebody is saying that that's what brought me to constitutional law, it opens questions. I don't have an answer, but it's certainly, I do find it puzzling.
Thank you. And Professor Liu, listening to the two cases you described, the 10-year-old boy shot in the back while by an officer who didn't believe he was armed, and in any event, he wasn't coming at the officer, he was leaving. TV in the hotel room, the bedroom. These things really bother me. And you now have the emerging story that the President may have violated, actually Congressional Research Service believes he has, and ordered others to violate the criminal provisions of the Foreign Intelligence Surveillance Act by spying on Americans. Do you think, from what you've seen here today, that we should take great comfort that a potential Justice Alito would stand up to the President on those kind of issues?
Well, Senator Leahy,
I look at how deferential he's been to law enforcement, and I served in law enforcement, as did our chairman. I have a very soft, warm part in my heart for law enforcement. The only thing in my office that has, personal office has my name on it is my shield from when I was in law enforcement. But doesn't this bother you?
well, Senator Leahy, it does, and I won't venture any predictions as to how he would perform as a justice, but I would say that what he urged the committee to do was to believe that he would behave as a justice as he's behaved as a Third Circuit judge. Let me say one thing about the memo. This memo that he wrote in 1984 is about 13, 14 pages long. The first 10 pages of the memorandum contain his own personal individual analysis of this case. I urge all members of the committee to read it, if only to discover that he uses the first person throughout the first 10 pages of the memo. Only in the last 3 pages does he discuss whether or not the United States government should file an amicus brief on the side of the state of Tennessee. And what is ironic about the last 3 pages is that he observes that all federal agencies prohibit precisely this kind of use of deadly force. And that is one of the reasons why he urged against amicus participation in this case, because the United States government would be put to a difficult position to show that it really meant the rule that he would have urged.
Thank you. And Professor Gerhardt, I'm going to send you a letter. I had another question for you. I found very instructive your quick history lesson, as I have when you've given longer ones. Thank you, sir. Thank you, Mr. Chairman. And I apologize. I'm going to have to leave at this point for a while, but I know you got everything under control.
Thank you, Senator Leahy. Senator Kyle.
Mr. Chairman, let me just thank the witnesses for being here. I just am moved to make one comment, though. I can't dispute the analysis of individual items here, but I think in law we're all familiar with the best evidence rule, and the best evidence of how Judge Alito would serve on the United States Supreme Court, it seems to me, is not something that might have motivated him to be interested in the law 30-some years ago, or something that he even wrote as a young lawyer working in the administration, but rather his 15 years on the bench, number one, and secondly, how his colleagues have viewed his character as well as his judicial performance. And we've had almost 3 days to query him about all manner of issues. And I think to try to use the phrase cherry pick a particular comment that was made in a much different kind of context and read into that something more powerful than all of the other best evidence that we have is a real stretch. I'll just put it that way. I nonetheless appreciate the effort that all of you have made to be here to enlighten us in these hearings, and I thank you for your testimony.
Thank you very much, Senator Kyle. Senator Kennedy.
Thank you, Mr. Chairman. I was reminded of an extraordinary observation the other day, and that was that Robert Bork and Ruth Bader Ginsburg agreed 91% of the time. It was the 9% when they differed, which was the major differences. And that's something that I think sometimes we lose track of here when we're looking at overall statistics, overall figures. It's the dissents. And it is the close dissents, as the Professor Liu has pointed out, that really indicate on these enormously sensitive issues involving race, involving the disabled, involving women, that so much of a judge's philosophy comes out. I'm interested in, Professor, just if you'd talk a little bit about the jury selection cases. We've considered the two that Judge Alito was most involved in. One, which is pretty boilerplate and understand, the Brinson versus Vaughn case, and then the dramatic Riley versus Taylor case, which is just extraordinary and I think enormously distressful to many. I'd be interested if you would just talk about both and give us your assessment.
Sure. Well, Riley versus Taylor has been discussed in these hearings. That was a case that concerned a challenge to racial discrimination in jury selection in the Dover County court. It was shown that over the course of 4 murder trials within the same year, including the defendants in the case, the prosecution had struck every black potential juror to serve on a murder, on a capital jury. And the case was originally decided actually with Judge Alito in the majority, but it was then unbanked. And Judge Sloviter ended up with the majority opinion, basically finding that this pattern, in addition to other evidence in the record, showed racial discrimination in the jury. Judge Alito dissented from that view, and I think the sentence I think that is most disturbing is his comparison of that pattern to the right or left-handedness of presidents. And he went further to say that absent a careful multiple regression analysis, I can barely say it, we can't infer from this statistical pattern any racial discrimination. Now, the Brinson versus Vaughn case came along 3 or 4 years later. That was, I believe, a 2005 case in which there was a pattern of 13, I believe, out of 14 black jurors being struck. And Judge Alito wrote a unanimous opinion finding racial discrimination in that case. What is interesting about that case is that he relies on a prior case of the Third Circuit called Holloway versus Horn, which relies in turn on Riley versus Taylor.
Could you, just in the very short time, looking through the cases on these dissents, in areas of where Judge Alito took away the effect of a decision of a trial court to have a jury trial, number of cases that he took away from the trial court, and the number of cases that he took after there had been a jury trial on appeal where he ruled against the individual on that, effectively overriding or overruling the trial court. Number in both of those areas is some rather significant cases. We haven't got a lot of time here, but I think you get what I'm driving at in terms of the respect for the trial court and the jury verdict. Whether you feel from your own kind of analysis the appropriate kind of respect and tradition for that.
Well, I think one area in which there is a, to my mind at least, a somewhat disconcerting pattern is in the Fourth Amendment context. You know, much has been said about, for example, the Doe versus Grudy case. What I find puzzling about that case is it is not that there is nothing to Judge Alito's position. I think if you read
this is the strip searching of the child.
His opinion actually is like all of his opinions, incredibly well reasoned, very thoughtful. It is not at all disparaging to the girl or her mother who was found to be illegally searched. What is interesting to me is that in that case there is the availability of 2 competing interpretive principles. One is read the 4 corners of the warrant for what it says. The other is supplement the 4 corners of the warrant with underlying material that is questionable, at least in terms of whether or not it is incorporated. Given the important dignity at interest in Doe versus Grudy, it just strikes me as puzzling why he would have chosen the second interpretive device rather than the first. And the second one is the one that took the case out of the jury's hands to determine whether or not the search was or was not reasonable.
This is the one where Judge Chertoff took exception to Judge Alito. Thank you very much. My time's up.
Thank you, Senator Kennedy. Senator Sessions.
Well, on the Doe case, Mr. Phillips, Doe versus Grudy, this was a question involving a lawsuit. You, as a Solicitor General, you've had to defend law officers for personal damages who are being sued. At best, there was an appearance, was it not, that this affidavit was in fact made a part of the warrant because the magistrate judge intended it so and said it.
Right. Senator Sessions, I mean, that is, at least to my mind, the complete answer to the professor's argument, which is this doesn't have anything to do with two different analytical approaches. It has to do with how do you apply qualified immunity and what deference do you owe to the individual officer who's in a very precarious position making decisions on the fly. And you know, I think if you read the opinion, it's quite, as he said, scholarly, thoughtful, analytical, almost apologetic with respect to the consequences to the individuals involved, but still recognizing at the end of the day that qualified immunity is designed to provide precisely the kind of gatekeeping function that the court exercised there in order to take those kinds of issues away from the jury, because that's the only way you can protect the greater societal interests that are implicated.
So he did a search warrant on a house where dope dealers were there, and he followed the instructions of the magistrate. They conducted a search of the young girl in a private chamber by a woman officer without removing all of her clothes, just pulling down her outer garments and a blouse up, apparently. And from the indications of the magistrate, that was permitted. And so the question was he acting within the line of scope of his employment, and was this officer subject to personal suit for money damages? Isn't that correct?
That's absolutely right, Senator.
Well, I'm telling you, police officers have a hard enough time understanding these laws of search and seizure. They are very complicated. And the judges throw out searches all the time when they're not proper. But to sue the officer who's trying to do the right thing, I think Judge Chertoff was in error. I'd like to see him back on here. I served the U.S. attorney with him. I'll ask him about that case. I think the Judge Alito was correct. Maybe he was not. But I think he had a good basis for that decision, and so I'm concerned about it. And Mr. Liu, with regard to the Cathcart case, in your written opinion here, you quote a dissenting opinion from Judge McKee that said that this is where you criticized Judge Alito for holding that there was not a basis for arresting a black individual who was in a black sports car after some armed robberies that occurred. And so that was a message apparently that went out, and the officer stopped the car and arrested this individual who was black in a black sports car. And the judge said that's not enough. That's basically racial profiling. And he left open, as I understand, the question of whether or not the stop was legitimate. And this judge, correct me if I'm not wrong, and maybe some of you prosecutors would jump in, but the Judge McKee, you quote favorably here, said, just as the record fails to establish that Officer Nelson had probable cause to arrest any black male who happened to drive by in a sports car, it also fails to establish reasonable suspicion to justify stopping any and all such cars that happen to contain a black male. Now, isn't there quite a difference of proof standard between the authority of an officer to arrest someone and the authority of an officer to do an investigative stop? Isn't that clearly a different standard? And wasn't Judge Alito correct to suggest that there's a different standard for the investigative stop than it is to arrest someone?
I think that's true, Senator Sessions. There is definitely a difference of standards. One is a reasonable suspicion standard, the other is a probable cause standard. In this case, I want to be absolutely clear in my testimony. I'm not criticizing Judge Alito for his result. I'm saying he's correct, but Judge McKee is saying that he didn't go far enough. Judge
Right, but
McKee is dissenting to the other side of Judge Alito by saying that by the same logic that racial profiling prohibits the probable cause finding, it also prohibits the reasonable suspicion finding.
Well, in that, I think the law is clearly to the contrary. I think officers who have that kind of information can at least stop a vehicle. At least there's certainly far more authority to do that than it is, and the standard is different pretty clearly. Thank you, Mr. Chairman. I won't continue.
Thank you very much, Senator Sessions. Senator Biden.
Professor Gerhardt, I'm just curious, was that the case you cited about the Hoover administration? Was that when Senator Borer went down and said to, it's a good answer, I think, to the chairman. Senator Borer went down, and when he was given a list of 10 people, looked at the list of the president, he said, it's a great list, Mr. President, but you have it upside down. And that's how you get the message, because when presidents actually consult, you do have an impact. Let me ask you, Professor Gerhardt, and I understand if you don't want to answer it, but where do you think on the spectrum of the present court, if Judge Alito is confirmed, he will end up?
It's a great.
That's guessing. But I mean, what's your best judgment?
It's a great question, Senator, and obviously, I think it's one of the central questions in these hearings. I can tell you this much: I know how the president answers that. The president said he wanted to nominate somebody in the mold of Justice Scalia and Justice Thomas, and I think one of the questions in these hearings has been the extent to which, for instance, Judge Alito is going to be perhaps more like those justices, or perhaps like some other justices, maybe Justice O'Connor or Justice Harlan, as he suggested, and so. If he is going to fit that mold, then obviously the balance shifts in a number of important cases in a certain direction. But if he's not, then of course it's going to be harder to predict. I might venture at least this much. I think that if he is truly going to be a bottom-up judge, as he suggests, then I think the shift is not going to be that great. In other words, the shift would be more modest. That's the critical thing. The critical thing about being a bottom-up judge is that that is the essence of modesty. There's very little margin of error when you're a judge and you're a bottom-up judge. But if you turn out to be a top-down judge, there's a greater potential for margin of error. And so if he does turn out to be more like Justice Thomas and Justice Scalia, there's greater possibility for error.
Well, there'll be an awful lot of disappointed folks in Washington and the nation if he turns out to be like Justice O'Connor. A lot of people will be very upset who are supporting him now. Let me ask, if I may, anyone who'd like to respond in the panel. One of my greatest concerns is, and I must tell you, I have a diminishing regard for the efficacy of hearings on judicial nominees in terms of getting at the truth. I'm not in any way implying.
Based on a panel?
Yeah. No, I'm not in any way implying. Across the board, Democratic nominees, Republican nominees, it goes to this issue, in my view, of do the people have a right to know what they're about to put on the bench? And the part that concerned me the most, I must tell you, is the judge's comments on, or failure to comment on, at least my view, a clear understanding of what he means by the unitary executive. It seems very different than what others think the unitary executive means, and scholars that I'm aware of, and his discussion about or failure to respond to what is now a very much animated debate about whether or not the president can wage war without the consent of or authority from the Congress, and whether or not, as the administration argues, the War Powers Clause only gives the Congress the power to declare war if it wants to when the president doesn't want to go to war, which is the most extreme reading I have heard other than one occasion in the Bush 1 administration. So does anyone here have have any doubt that there's a need for the president, absent imminent danger, to get the consent of the Congress before he were to invade Iraq or Syria tomorrow? Or does the president have the authority tomorrow, based on his judgment, to invade Iraq and Syria? Anybody want to venture an opinion on that?
I think, Senator Biden, that the lesson of the steel seizure case, and including Judge Alito's invocation of Justice Jackson's opinion in that case, is that the President acts at tremendous constitutional peril when he acts contrary to the express wishes of Congress, and acts at significant constitutional peril when he acts absent congressional authority, unless there is true military exigency of the moment. I think that that's fairly well established. That's been the history of the relationship between Congress and the executive. It's been a difficult history, and the question of how much authorization Congress has given is a repeated issue before the courts, and has been since the Civil War cases. But I don't think that there's any doubt on this question constitutionally.
Thank you, Mr. Chairman. My time's up.
Thank you, Senator Biden. Senator Cornyn.
Thank you, Mr. Chairman. I guess I just have to express some reservations at trying to predict how Judge Alito is going to rule on the bench. I can think of famous examples where President George Herbert Walker Bush thought David Souter was going to be of a particular frame of mind or approach on the bench. I guess, who was it? Richard Nixon probably had some ideas about Harry Blackmun. And President Eisenhower had some ideas about Earl Warren. I mean, this is judicial independence means something, and what it hopefully means is that exactly what the framers intended in terms of providing the flexibility, the freedom, the independence. They have life tenure. We can't cut their salary. You know, who knows? I mean, this is I guess a debate only lawyers can love. But it's important, but I just don't know how we can answer the question comprehensively. Professor Zakharoff, it's good to see you again. Of course, I got to know you during your tenure at the University of Texas Law School before you came up north to NYU. But I wanted to, you know, there's been some questions about Judge Alito's statements back about his concerns about the Warren Court decisions on reapportionment, and you've alluded to that in your testimony. And you know, the fact is our nation has a checkered history, doesn't it, in terms of enfranchising people, making sure that everyone's vote counts roughly the same. Back, I guess, at the beginning of our nation, people had to have property before they could vote. We know that some people couldn't vote at all, African Americans, and we fought a civil war and amended the Constitution on that. And we know that there's, even today, the Texas congressional redistricting case is pending before the United States Supreme Court. So, but just to, this remains a subject of a lot of interest and a lot of controversy, but I just want to make sure that we are not guilty, those of us on this side of the dais, about overstating or reading too much, I should say, into what Judge Alito has said. He said in college he was motivated by a deep interest in constitutional law, motivated in large part by disagreement with Warren Court decisions, particularly in the areas of criminal procedure, the Establishment Clause, and reapportionment. Let's talk about reapportionment, which is, I know, one of your passions and expertise. It wasn't until 1962 when the Supreme Court decided that those issues were justiciable in the first place. Wasn't it in Baker versus Carr?
That's correct, Senator.
And then the principle of one person, one vote was decided in Reynolds versus Sims in 1964, I believe. Is that the right time,
yes.
Right case?
Yes.
And of course, notwithstanding what some have tried to make out of what Judge Alito said, he's testified here and in other areas that he considers one person, one vote a bedrock of our democracy. And you said that's, you know, everybody believes that, at least every American believes that today, although it was fairly controversial not that many decades ago, or at least in terms of the court's role. What he did say, and I want to get your comment on this, is that, and maybe it was because of his father's experience, as you alluded to a little bit, that strict numerical precision in terms of the size of districts, whether they be for city councilman, whether it be for state representative, a state senator, or congressman, or whatever, there was there's sort of the troublesome issue of how do you deal with things like municipal boundaries and communities of interest, lines that ordinarily you would think define those communities of interest in a way that you just don't want to run roughshod over. Is that a legitimate consideration on the way to try to achieving that goal of one person, one vote, or is that just bogus?
I think, Senator, and I still have the temptation to refer to you as Justice Cornyn, but Senator, I think that that it is absolutely a legitimate concern. I think that one person, one vote turns out to do two things. One, it's emblematic. It's our aspiration that everybody be equal in the political process. And secondarily, and perhaps more importantly, it serves as a check on what those in power can do to try to preserve themselves in power. And that second feature of it has been difficult. And the efforts to ratchet up mathematical exactitude have usually come in cases that were about something completely different. For example, in the New Jersey case in the mid-1980s, Karcher versus Daggett, the real issue was a partisan gerrymander, and everybody understood that. And the court didn't know what to do about it, just as it's had trouble with that issue for the decades since. And so it fell back on this extraordinary mathematical exactitude, which in fact is completely illusory because the census isn't that precise. So I agree with you fully. I don't think that that was where the controversy had moved in the late 1960s. I'd stay by that statement. But nonetheless, you're absolutely right that this is a legitimate source of concern.
Professor, thank you. My time is up. I appreciate your response to my answer, to my question. Thank you.
Thank you, Senator Cornyn. Senator Coburn.
Thank you, Mr. Chairman. I've been listening. I was not here for all of it, but I was paying attention by the video screen in the back room. And I just some observations. I live on Capitol Hill with two Democrats, and the thing that's normally asked of them is, "How can you live with that guy?" And their answer is you don't know his heart. And then I get asked the same thing. How can you live with those two guys? And I say, you don't know his heart. And it strikes me as I look at this panel, the three people who testified favorably for Judge Alito know him. And the three people who didn't testify, who testified somewhat negatively about Judge Alito, don't know him. They've read some of his cases, not all of his cases. And so it just kind of strikes me that one of the most valuable pieces of information that this committee has gotten from outside witnesses was the judge panel that came before you. The people that have worked with him for over a decade, worked with him in a closed room, I believe they know his heart. And I believe anyone in this room, you can take anything that we've written at some time or said at some time, and you can make each of us look terrible. And I only have really one question, that's for Professor Liu. How do you explain the fact that Judge Lewis, who is adamant about Title VII of the Civil Rights Act, his observations about Judge Alito are completely contrary to yours? How do you explain that? Here's a guy that knows him. Here's a guy that has very liberal leanings in terms of the political spectrum. Here's a guy that is basing his whole legal career on civil rights. And yet he says, I know this man, and there's not a bit of truth in any bias or any direction that he goes. How do you explain it?
Well, Senator Coburn, I certainly can't dispute Judge Lewis's account or views on Judge Alito. I understood the previous panel to be testifying to the integrity and intellectual honesty of the nominee, none of which I dispute. In fact, I conceded in the very first sentence of my testimony that I find him also to be an intellectually honest person. My only viewpoint, I guess, that I'm offering is not really a viewpoint at all. What I'm trying to simply urge is that that some attention be paid to his record, and that the record speaks for itself. And it doesn't speak to the nominee's intellectual any negatives regarding the nominee's intellectual honesty. Rather, I think it speaks more to the set of values or instincts or the intangible qualities of judging, I think, that every judge, every human being brings into the world. It is not that any judge decides to go about any case saying, oh, I come in with this bias or I come in with that bias. I grant that Judge Alito, like every judge, tries to be impartial, but every judge also has a set of instincts, a central tendency, and I think it can be revealed, not definitively, but it can be revealed by looking at patterns across large numbers of cases.
And you looked at 50 cases of his, is that correct?
Well, I've actually looked at more, but the cases that I've...
How many more?
I've probably looked at 60 or 70 cases.
Out of 4,000?
Out of the 360 that he's written.
The written opinions on, but he's still has adjudicated over 4,000 cases.
Certainly that is true.
All right. Thank you, Mr. Chairman. I yield back.
Thank you, Senator Coburn. I had hoped to finish up this evening, but the sense of the proceeding at this point is that it's not a wise thing to do. This panel took an hour and 15 minutes, and projecting with a break, we'd be in the 10 o'clock range or perhaps even later. That would depend upon how many senators were here to question. And I think in the morning we may have more questions. And I think it is a fair observation that we're not at our best into the started at 9, so we're in the 10th or 11th hour. And we do have tomorrow to proceed and still meet the schedule that I had announced early. I know that it's a likely inconvenience to some of the people who were on the later panels, although nobody on the latter panels, if we were to finish tonight, would be out of this town tonight anyway. So it's really staying over, and I know that in making your plans to come here, you didn't know whether you testify on Thursday or Friday, and nobody else knew whether you testify on Thursday or Friday. We tried to follow the Roberts model, but on Roberts we finished up his testimony close to 11 o'clock, and today we didn't start on the outside witnesses until 2:30. That's probably more than you want to know, but I'd like to tell you what's on my mind. I see some of the witnesses on the later panels nodding in affirmative. Nobody seems to be too distressed about calling it a day at 6:36 after starting at 9 a.m. So we will begin tomorrow morning at 9 o'clock.
Mr. Chairman, could I enter in the record a letter from the National Association of Women's Lawyers in an appropriate place, and then also a letter from Professor Higginbottom as well, an appropriate place in the record?
Certainly, without objection, they will be placed in the record at what we conclude to be an appropriate place after consulting with you. Thank you all very much. That concludes our hearing.